On the record in cause number 322600. The case is styled of State of Texas versus Emily C. Cook. We have Emily C. Cook, who is present. Ms. Cook, is that your full name?
Yes.
And we have Ms. Cook, who's present here with her attorney, Jack Lawrence. Ms. Cook, how are you doing?
I'm good, how are you?
I'm doing fine. Thanks for asking. And Mr. Lawrence, how are you doing?
Just fine, Your Honor.
Okay. Now we have a motion to revoke the probation of Miss Emily Cook, who is appearing in court. State, Miss Maxie, are you going to be handling this case for the state?
Yes, Your Honor.
Okay. Now, the docket sheet states that this is a contested hearing on a motion to revoke probation. Is that correct, Ms. Maxey?
To my knowledge, Your Honor.
And Mr. Lawrence, is that correct?
Yes, Your Honor, but I would say, I need to, before we get started, I need to say that my impression, I didn't know it was going to be a full revocation attempt. I thought this might be a modification or something, because I had exchanged some emails with Julie and.
Before we,
I just want to say, I don't have all the
okay,
notice necessary under due process for what I understand is going to take place. And under
Miss, could you give me a copy of the notice that was sent to him? Okay, now, Mr. Lawrence, you stated that you didn't receive the requisite notice.
well, as to what was going to be happening, I'll just simply read you what kind of notice is required from the case of Belk versus Perquette, which is 15 F 3rd 803, decided in the 8th Circuit 1994. And basically it just follows what's required under Marcy versus Brewer is, Belk versus Perquette was a parole revocation. It was a small distinction because under Marcy versus Brewer, the due process required for parole and probation revocation is the same. Notice was unclear as to the charges against the parolee. He had not been permitted to examine written statements of witnesses or evidence reports regarding actions that formed the basis of revocation. He was not given opportunity to confront and cross-examine the adverse witnesses during the hearing. And the final statement that his parole was being revoked because he had violated certain laws was not precise enough to provide a basis for organizing how he would try the case so as to appeal it. It also, Belk versus Perquette also requires findings of fact and conclusions of law. And I can actually give you this copy, which comes from this is a memorandum I had Bill Hayburn is a real good friend of mine, and this was a memorandum Bill Hayburn had done, and he had attached this Belt versus Burkett case, and I'll just give you a copy of the case if you like. Your Honor.
Well, just hold on a minute. State, you have a response?
Yes, Your Honor. This motion to revoke probation was filed with this court on January 14th of this year. Within that motion, there are 7 listed violations detailed. Additionally, Mr. Lawrence was appointed as counsel in March of this year. And also, we are at a contested hearing today at the request of Mr. Lawrence. So any notice that he is lacking, or I believe that the state has fulfilled any notice requirements necessary. Additionally, we are at a hearing today to determine the validity or whether or not this probation should be revoked or not.
Can I briefly reply, Your Honor? Everything she says may very well be true. I did not understand what the substantive grounds for revocation were going to be beyond certain basics, which were brought up in the last hearing. Now, here's the thing. The things Julie and I had talked about on our
Sir,
email.
let me
We
just
had
say,
sent several emails.
Mr. Lawrence, whatever negotiation you and the prosecutor had is between you and the prosecution. The question here is based on whether or not you received the requisite notice of a hearing, well, of the motion to revoke probation, the allegations in the motion to revoke, and you requested a hearing, you requested the contested hearing, and now you come here today and saying, oh, we didn't receive the requisite notice of what Ms. Cook, what the allegations are, I guess, of in the motion to revoke. I think the case that you cited stated from the words that it was first of all, it involved a federal case. It was not a case, you did not cite a Texas case. And second, you said it was I guess the violation was uncertain. And if you received a copy of the motion, are you saying that the allegations in the motion to revoke is uncertain? Because I think the case that you cited did not have any specific allegations on the motion to revoke the individual's parole. And I think if we look at this case, if you're saying that you didn't receive notice because the violations was of a certain law, that does not appear to be the case in the motion to revoke probation, and that the court is taking judicial notice of this motion that is filed in this case.
What I said, Your Honor, was substantive grounds. What I had, that was why I had written some emails to Julie, and we had actually talked about, well, maybe she could get AA classes and things. We had talked
Mr.
about
Lawrence, hold on.
possible-
That's negotiation. I'm not talking about negotiation. You're trying to avoid the issue. The issue is
No, no, Your Honor.
whether or not on the face of the motion that she received notice of what she's been
I
charged
have a
with.
copy of that.
Right.
I-
And this, and the issue in terms of due process, the defendant must receive written notice of the grounds of revocation. You have a copy of the grounds of revocation. This is totally the opposite of the case that you have cited which involved parole. And so the issue of due process, if you said you received these allegations which are specific, the court is of the opinion that she received notice.
This is the first notice I had that it was not going to be some kind of modification.
That is not,
I
hold
got
on,
this
no, no.
last night.
Okay, Mr. Lawrence, you stated you received a copy of the motion to revoke. A letter, she's not being
Yes.
revoked based on that letter. She's being revoked based on the allegations in this motion.
But
This is
it
the
looked
notice
like
that
we
she
had-
needs.
Looked like we had a modification pending from what our exchanges.
Did you read the motion?
Yes, I've read it thoroughly.
Okay, does it say anything about a modification?
No, it does not. And I was expecting to have a contested hearing until
That-
I began negotiating.
Well,
And at that time, I thought, and then I got this last night. And it says probation department, it looks like they want to revoke them.
okay, so your objection will be overruled. Okay, your objection is overruled.
That's fine.
Do you want to still go forward with your,
Sure,
the contested hearing?
sure, Your Honor. A lot of it's about her ability to pay.
Well, we'll get into the allegations during the contested hearing. There are several allegations. Okay, now the state has the burden of proof. And the state has to prove its case by preponderance of the evidence. Do y'all need some time?
I believe we're ready, Your Honor.
Y'all ready to go forward? Now, let me ask you this here, y'all like to, I don't know, y'all like to sit at your tables or Mr. Cobb and Miss, we're gonna,
We could stay.
the
we can stay
prosecution-
up here, Your Honor.
it's up to y'all. They want to,
I think they could hear me better.
yeah, hold on, Mr. Lawrence. Mr. Lawrence, just have a seat at council's table,
Right, Your Honor.
you and your client. And we'll have
Could you tell me, are we under 42A 752 Code of Criminal Procedure and 42A 755? Yes.
reduction or termination of community supervision period.
2A 752 and 755, I think. And also
This
753.
revocation, violation, condition, community supervision, detention or hearing, and hearings 42, 751.
I think it's 752, 753, and 755, Your Honor, if I'm correct. I was,
Well, you, I mean, you,
those are the ones
well, you
that-
gotta start, I mean, all of these, you even start with 42A 751 also applies. Plus it talks about the court retains jurisdiction to hold a hearing under subsection 1 of D, and to revoke, continue, modify community supervision regardless of whether the period of community supervision imposed on the defendant has expired, if before the expiration of the supervision period. I mean, it's under all of these, it's under this subchapter P, revocation, that's titled subchapter P, which is titled revocation and other sanctions.
Mhm.
Okay, so
Yes, Your Honor.
all of these code provisions will apply.
Yes, I believe 42A 751 I, subsection I definitely applies in this case.
Okay, well, just have a seat and we're gonna get started on the hearing.
Yes, Your Honor.
State, are you ready?
Yes, Your Honor.
Defense, are you ready? Oh, Mr. Lawrence,
Could I put this somewhere? Your Honor?
here's a trash can somewhere.
That'd be good.
Now, Miss, Max, are you gonna read the motion? And we'll ask, Ms. Cook, you'll stand, and, we'll either get true or not true to the allegations. Would you please stand? Would you go, Ms. Maxey?
Yes, Your Honor. To the Honorable Judge of said court now comes the state of Texas by and through Julie Maxey, Assistant Criminal District Attorney for Jefferson County, and respectfully shows unto the court the following: that Emily C. Cook, defendant in the above styled and numbered cause, was tried on the 8th day of January 2020 for the offense of DWI enhanced blood alcohol content greater than 0.15, a misdemeanor, and that on such date, the said defendant was found guilty and assessed punishment at a term of 180 days confinement in the Jefferson County Jail and a fine of $750, and in accordance with the provisions of Article 42.12 of the Code of Criminal Procedure of the state of Texas. Said confinement was probated for a period of 2 years upon the condition that Condition 7, remain in the following location, Jefferson County. Condition 12, abstain from the use or possession of any drugs except those taken or possessed under doctor's orders. Condition 13, never become intoxicated or be under the influence of any intoxicating substance. Condition 14, pay for, attend as directed, and successfully complete a DWI education program as directed by the court or probation officer. Condition 18, perform 80 hours of community service at a rate of 5 hours per week until completed or otherwise specified. That said defendant, after receiving said probation, violated the terms and conditions thereof in the following manner to wit: that said, number 2, that the said Emily C. Cook failed to remain in the following location, Jefferson County, Texas, as ordered by the court by admitting to traveling to Austin, Texas on or about the 4th day of June 2020 through the 9th day of June 2020 without the permission of the Orange County Probation Department or the court, in violation of Condition 7 of the defendant's probation order. Number 3, that said Emily C. Cook failed to abstain from the use or possession of any drugs except those taken or possessed under the doctor's orders as ordered by the court, in that on or about June 4th, 2020 to June 9th, 2020, Emily C. Cook admitted use of the following legal drug, tetrahydrocannabinol, marijuana, in violation of Condition 12 of the defendant's probation order. That said Emily C. Cook failed to abstain from the use or possession of any drugs except those taken or possessed under doctor's orders as ordered by the court, in that on or about July 16, 2020 and October 15, 2020, Emily C. Cook provided a urine sample for a scientific analysis that showed the presence of metabolic byproducts of tetrahydrocannabinol, marijuana, in violation of Condition 13 of the defendant's probation order. Number 5, the said Emily C. Cook has failed to complete a DWI education program as ordered by the court in violation of Condition 14 of the defendant's probation order. Number 6, the said Emily C. Cook failed to perform the community service hours required as ordered by the court in violation of Condition 18 of the defendant's probation order. Premises considered, therefore, the Assistant Criminal District Attorney of Jefferson County, Texas, moves the court to cause a warrant to be issued for the arrest of said defendant, and upon defendant's arrest, the hearing be held and probation revoked in response as evidence and judgment of the court thereon be warranted.
Now, let's state, are you abandoning allegation 1 and 7?
That's correct, Your Honor.
Okay, it was so noted. Now, Ms. Cook and Mr. Lawrence, the allegation number 2, the said Emily Cook failed to remain in the following location, Jefferson County, Texas, as ordered by the court by admitting to traveling to Austin, Texas on or about the 7th day of June 2020 through the 9th day of June 2020 without the permission of Orange County Probation Department or the court.
She would plead true to that, Your Honor. She would plead true to that one.
Okay, now, condition number 2 states that the said Emily C. Cook failed to abstain from the possession of any drugs except those taken or possessed under doctor's order as ordered by the court in that on or about the June 4th of 2020 to June 9th of 2020, Emily C. Cook admitted use of the following illegal drug: tetrahydrocannabinol, which is marijuana, in violation of condition 12 of the defendant's probation order. Is that true or not true? True?
That was during the Austin trip, if you look at the 2 allegations.
Okay.
And that was a year ago.
Okay. Now, allegation number 4 alleges that Emily C. Cook failed to abstain from the use or possession of any drugs except those taken or possessed under doctor's orders as ordered by the court in that on or about July 16 of 2020 and October 15 of 2020, Emily C. Cook provided a urine sample for a scientific analysis that showed the presence of the metabolic byproduct tetrahydrocannabinol, marijuana, in violation of condition 13 of the defendant's probation order. Is that true or not true?
That's true.
Okay, now allegation number 5 alleges that the said Emily C. Cook has failed to complete a DWI education program as ordered by the court in violation of condition 14 of the defendant's probation order. Is that true or not true?
Number 5.
Yes.
It say, I'll read it again. It says that the said Emily C. Cook has failed to complete a DWI education program as ordered by the court in violation of condition 14 of the defendant's probation order. Is that true or not true?
Your Honor, she's having difficulty with transportation.
Okay.
I'm pretty sure I have this one completed. The DWR
Oh,
education program.
okay, so that's not true?
Yeah, it's not true.
Okay,
At this time, I'm sure.
okay. Now, condition number 6, or allegation number 6, alleges that Emily C. Cook failed to perform the community service hours required as ordered by the court in violation of condition 18 of the defendant's probation order. Is that true or not true?
That's true. Probably need a little less than that.
So, Ms.
No, they're talking about hours.
Yeah, well, completed.
Right. So, Ms.
How much have you completed?
I think 200 on it. I'm not sure how many that is.
I'm not sure. I'm not
30
sure.
hours out of 80 hours.
Oh.
Somewhere around
Okay, so Ms. Cook, are you pleading true to allegations 2, 3, 4, and 6 freely and voluntarily?
there. Yes, Your Honor.
And are you pleading true to these allegations because they are true?
Yes, Your Honor.
Okay. Oh, okay. You may be seated.
Your Honor,
It
may I
seems,
comment first?
well, let me do this. It seems to me that she's played true to all but one of the allegations that was not abandoned. I'm trying to understand why it's the hearing contested. If she's played true to these allegations. I mean, if you wanna, she's already played true. If he wants to argue something, because these allegations are not contested if she played true. So, we can, if you want to, argue, punishment, at this point, we can do that. Or unless you want to talk to the prosecutor to see if y'all can come to some type of agreement.
I would prefer to do that, Your Honor. One of the big things.
Okay. Well, let me do this here. Let me give you and the state an opportunity to talk, okay? And so what we're gonna do, we're gonna go in recess. Madam Prosecutor, do y'all want to talk in the conference room, or y'all, if y'all prefer to talk here, I'll just leave and let y'all talk here. It all depends on where y'all wanna.
We can talk in the conference room.
Okay.